2 of the jurisdiction report. Now, you know, if you've been watching, this is jurisdiction over federal areas within the states. And this is a continuation of the other videos I have on this topic, and basically territorial jurisdiction. Okay, so we're going to go down to chapter 2, and it says history and development of federal legislative jurisdiction. Okay, so what it's talking about here is why they put in the Article 1, Section 8, Clause 17 section, where it talks about the federal government being the authority on the federal lands without state interference, and why they needed to do that. So real quick, I talk about this section all the time, and we'll go over it real quick. It says to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 square miles as made by session of particular states, and acceptance of Congress become the seat of government of the United States, which is the lands for military purposes, and to exercise like authority over all places purchased by the consent of the legislator of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Okay, so what this is saying is exclusive jurisdiction, exclusive legislation, that's called exclusive legislative jurisdiction, means that on the lands that the state gave to the federal government for federal purposes, that the state promised not to interfere. Okay, and then it had like authority over the places it purchased. So the places purchased in the states, or the places that were annexed to the federal government, that the federal government had legislative jurisdiction over those places. Okay, so history and development of federal legislative jurisdiction. Origin of Article 1, Section 8, Clause 17 of the Constitution. So what I want you to be thinking of when I read this is that the federal government wanted a place to do federal things, which were forts, magazines, arsenals, military things, without people coming in and harassing them and stopping them. So they wanted these places to be cut out and given to the federal government, and that nobody from the state, meaning that there were state people and there were federal people, but nobody from the state could come and interfere with what they were doing, because they were supposed to be doing things for defense with a C. And when you're trying to equally defend all the states, you can't have people coming in and taking things away and doing things and kicking people out, because then all the states are not equally defended. Okay, now what it has become is just a big monster that's gotten so out of hand that it can hardly be recognized, and they use deceitful practices to do it. One of those deceitful practices are the vague terms that they use, and the corporations that they institute as instrumentalities to expand itself. Okay, so what it was intended to be and what it is are two different things. So let's see what it says, and it's talking about the article, section, and clause that I just read to you. This provision was included in the Constitution as a result of proposals made to the Constitutional Convention on May 29th and August 18, 1787 by Charles Pickney and James Madison, both who signed the Constitution. So really, they could say it was for whatever reason they wanted. It didn't have to actually be for this reason. They could have just said, this is the reason we want it in there, but it could have been for any reason. The clause was born because of the vivid recollection of the members of the convention of harassment suffered by the Continental Congress at Philadelphia in 1783 at the hands of a mob of soldiers and ex-soldiers whom the Pennsylvania authorities felt unable to restrain, and whose activities forced the Congress to move its meeting place to Princeton, New Jersey. Okay, so remember, I talked about constitutional law as fiction, and how things are written in such a way so as to convince you, but not necessarily are facts. Okay, so what I'm saying is this could very well be just to convince you and not necessarily a fact. Okay? They could have had an alternative reason. I think the reason was a good one, and that's where they should be and that's where they should stay on federal lands. But what I'm pointing out to you is another way to see fictions when you're reading things. The delegates to the Continental Convention, many of whom had suffered indignities at the hands of this mob as members of the Continental Congress, because I believe Pinckney, I think he was the guy that was tarred and feathered because people believed him to be a loyalist. Okay. Continental Congress were impressed by this incident and by a general requirement for protection of the affairs of the then weak federal government from undue influence by stronger states, to provide an area independent of any state and under federal jurisdiction in which the federal government would function. So it was like afraid that some states would overpower it. Okay, and they wanted all the states to be equally protected, and so what it did was it took over the protection system of all the states. So it gave itself the power to become a military, and they put all the military in all the states under a single force, which is the Congress and the president as the commander-in-chief. So it can come up with a million different pretty little reasons that people will accept to do this, but in reality, what it wanted to do was protect itself. This area and these people wanted to protect themselves to make sure that no state became more powerful than any other state, and that the bigger states could take over the littler states, because like you see in the West, we have very large states where if they became more populated, they could become more powerful and take over the eastern states that were very small. Without much debate, there was accepted the theory that places other than the seat of government, which were held by the federal government for the benefit of all states similarly, should not be under the jurisdiction of any single state. So it's saying that the seat of government should be controlled by all the states, and these are the independent states, not the states created by the federal government inside the independent states, which are dependent states. Okay, so it's saying that, I mean, basically they were scared. They were scared that when the West started growing up, that the West would say, no, we don't want to be a part of you, and they would become independent nations, and that they would overtake the smaller states. And the smaller states were afraid of that. So we not only had to worry about, or they not only had to worry about the king coming over and fighting another war, but they had to worry about the states fighting each other. And they didn't want the states to fight each other. They wanted the states to be under a central control. As we see now, that central control has gotten so far out of hand that that seat of government is now taking over the entire states. Okay. Objections made by Patrick Henry and others based upon the dangers of personal rights and liberties which Clause 17 presented were anticipated or replied to by James Iredell of North Carolina, subsequently a United States Supreme Court Justice, and Mr. Madison. They assured that the rights of residents of federalized areas, okay, because they were concerned. See, what they said in Federalist 43, paragraph 2, is that they were concerned that the people in the state, in the federal areas in the state, would not allow the federal government to take it over. So the federal government wanted to make sure that it covered all its bases. And so what they did was they had the entire people of the whole state vote. And so they felt like they got a say-so. And then they allowed the people on the federal areas that were annexed to the federal government, they allowed them to vote also. And they wanted to make sure that the people of the federal areas felt like their rights would be protected. And the states were also concerned about the people that were living on the areas that were given to the federal government. So, for example, we have Texas here, and we see the blue areas that were the original lands annexed to the federal government for the purpose of building forts and such. Some of these are so small you can hardly see them. Here's Randolph Air Force Base, Brooks, Fort Sam Houston, Lackland. Here's a big blue area. That might be a lake. This is Canyon Lake. Belton Lake, Fort Hood. Okay, Camp Swift. There's some places I think over here somewhere. There's Ellington. Yeah, wherever else they have. Okay, so these federal areas that were annexed to the federal government had people living on them. So they wanted to make sure that those people's rights were protected. There you have a Bill of Rights. It's for those people that were living on the federal lands when the lands were annexed. Okay, so the government had to put all these things in there. Some of these people had the land patents for these lands. And so they're sort of like cut out of the federal areas. And so when it talks about having a right to vote, they had a right to vote in the federal elections because they lived on federal lands. Okay, they have federal addresses. And so when they're talking about, certain types of aliens or non-resident aliens or non-citizens that live on the federal lands and all these things, it's talking about the people that own those properties when those properties were annexed to the federal government. They wanted to still make sure that these people had still state rights as well as the federal rights. Okay? I think we're really getting somewhere with this stuff. Okay, so these are the federalized areas, these lands ceded, and this is from National Atlas, which the website no longer exists. I went there, last time I went there, it said it expired. I don't know how the government expires websites. I mean, they could just put it under something else and still keep all the same maps, but I can't find them. But those are the rights of the residents in the federal areas would be protected by appropriate reservations made by the states in granting their prospective consent to federalization. So those prospective areas had people living on them that weren't part of the federal government, and they needed to be assured that those people would still have their rights. And those are the residents of the federal areas. Now, if you go to Fort Leavenworth, when I worked there, there was a big section of Fort Leavenworth that was considered Fort Leavenworth that was not owned by the federal government. It was private property, and there were these people that lived there their family had lived there for hundreds of years. And if you know anything about Fort Leavenworth, that land was annexed so far back. It's like, I think the first or oldest military reservation west of the Mississippi, I think is how it's said. And those people owned that property for a long time, but those properties, when Kansas joined the Union, was given to the federal government under federal control. And so their property came under the federal government, and their rights had to be protected. And so then they were given these reassurances, okay? And the state had to reassure this. And that's why some of these people are state residents as well as federal residents, okay? Early practice concerning acquisition of legislative jurisdiction. The federal city, okay, was established at what became Washington on land ceded to the federal government for this purpose by the states of Maryland and Virginia under the first portion of Clause 17. However, the provision of the second portion for transfer of like jurisdiction to federal government over the areas acquired for federal purposes was not uniformly exercised during the first 50 years of the existence of the United States. It was exercised with respect to most, but not all, lighthouse sites, with respect to various forts and arsenals, and with respect to a number of other individual properties, but search of appropriate records indicates that during this period it was often the practice of the government merely to purchase the lands upon which its installations were to be placed and to enter into occupancy for the purposes intended, without also acquiring legislative jurisdiction over the lands. Okay, so it's saying that it wanted to acquire property without also acquiring the jurisdiction of the land. And they did this a lot with some lands that Rockefeller had. So Rockefeller would have lands and he would either sell it or give it to the federal government and ask the federal government for a different portion of land. But he couldn't cede jurisdiction, like a complete legislative jurisdiction over those areas to the federal government because he wasn't the state, or he wasn't the legislator of the state. The legislature of the state has to cede jurisdiction over those lands. So it was sort of like a trade, but the federal government couldn't do whatever they wanted on those lands because they had only purchased it or traded it, and therefore only had the same type of power that any other person would have if they went and bought land. Okay, so there's different jurisdictions. Acquisition of exclusive jurisdiction made compulsory. Okay, so this is like through time, things are changing as they understand more and more what's written in the Constitution. They're starting to change how they're looking at things and what's the best way of doing things and how not to do things. So this has been like a process that's happened over time. The federal practice of not acquiring legislative jurisdiction in many cases was terminated in 1841 as a result of what appears to have been a legislative accident. A controversy had developed between the federal government and the state of New York concerning the title to, not the legislative jurisdiction over, a single area of land on Staten Island upon which a fortification had been maintained for many years at federal expense. Presumably to avoid a repetition of such incidents, the Congress provided by a joint resolution on September 11, 1841, set out in Appendix B to this report as Section 355 of the Revised Statutes of the United States, that thereafter no public money could be expended for public buildings, public works, which is maintaining public buildings also, on land purchased by the United States until the Attorney General had approved title to the land, and until the legislature of the state in which the land was situated had consented to be purchased. So what it says, what appears to be a legislative oversight, okay, that is a fiction. It appears to be something, it might not be. So appearing to be something is a fiction. I'm just trying to point some of these things out to you. Reference Constitutional Law as Fiction by LaRue. In facilitating federal construction within their boundaries, most states during the ensuing years enacted statutes consenting to the acquisition of land, frequently any land, within their boundaries by the federal government. So the states and the federal government weren't constituting correctly. These general consent statutes had the effect of implementing Clause 17 and thereby vesting in the United States exclusive legislative jurisdiction over all lands acquired by it in the states. The only exceptions were the cases where the federal government plainly indicated by legislation or by action of the executive agency concerned that the jurisdiction proffered by the state consent statute was not accepted. Necessity for plain indication by the federal government of non-acceptance of jurisdiction came about because of a general theory in law, because most of law is theory, that a proffered benefit is accepted unless its non-acceptance is demonstrated. So they're practicing law. They're trying to find out what works and what doesn't work. It should be noted that lands already under the proprietorship of the United States when these general consent statutes were enacted, such as the lands of the so-called public domain, were not affected by these statutes, and legislative jurisdiction with respect to them remained in the several states. Okay, so I want to point out public domain. Public domain, when we talk about federal public, we're talking about the federal lands. The federal lands are in the public domain. Okay, Bureau of Reclamation, Department of Defense, Fish and Wildlife, Forest Service, National Park Service. Curiously, therefore, the vast areas of land which constitute the federal public domain generally are held by the United States in a proprietorial status only. It should also be noted that in 1841, federal statute did not apply to lands acquired by the United States upon which there was no intent to erect buildings within the broad meaning of the statute. That means those statutes only applied to the seat of government, because they could only make statutes for areas that were purchased for erection of forts and such. However, the federal government quite completely divested the states, with their consent, of legislative jurisdiction over numerous and large areas of land which it acquired during the 100-year period following 1841, without apparently much concern being generated in a quarter for the generated in any quarter for their consequences. So they were doing things without concern, without any forethought. State inroads upon acquisition of exclusive jurisdiction. In the course of tremendous expansion of federal land acquisition programs which occurred in the 1930s, the states became increasingly aware of the impact upon state and local treasuries, which will be discussed in considerable detail. The federal acquisition of exclusive legislative jurisdiction and its further impact on normal state and local authority. With the development of this awareness, there began the development of a tendency on the part of the states to repeal their general consent statutes, and in some cases to substitute them for what may be termed session statutes, specifically ceding some measure of legislative jurisdiction to the United States, while frequently reserving certain authority to the state. In other instances, states amended their consent statutes so that such statutes similarly reserved certain authority to the state. Included among the reservations in such consent and session statutes are the right to levy various taxes on persons and property situated on federal lands and in transactions occurring on such lands, criminal jurisdiction over acts and omissions occurring on such lands, certain regulatory jurisdiction over various affairs on such lands, such as licensing rights, control of public utility rates, and control over fishing and hunting, and the most complete type of reservation, a retention by the state of all its jurisdiction, while concurrently granting all jurisdiction or some measure of jurisdiction to the federal government. It should be emphasized that federal instrumentalities, which are businesses created by the various agencies, and their property are not in any event subject to state or local taxation or to most types of state or local controls. However, the transfer to the United States of exclusive legislative jurisdiction over an area has the effect, speaking generally, of divesting or taking away the state and any governmental entities operating under its authority of any right to tax or control private persons or property upon the areas. So it's talking about the state giving up the land and then removing itself the right to tax the people on those lands. So when the state gave up property to the federal government, it gave up some certain rights, and taxation was one of them. It was the divesting of such rights that reservations and consent and session statutes were designed to combat. And something I wanted to talk about up here was that it says that it could repeal session statutes. And from my understanding, the way you get into something is the way you get out of something. That's an ancient maxim of law. It goes back for a long time. And what you do is you repeal it. Whatever law it was, you repeal it. You go to Congress, you pass a law, and you say this law repeals the other law. And for example, the Constitution never specifically states that the Articles of Confederation were repealed. Now, this is an ancient law that is true law and goes back for thousands of years, that whenever you make a law that replaces an older law, the new law has to specifically state this law repeals the older law. So for the lawful state created by the inhabitants of the people, the legislature of the state has to repeal the law where Texas joined the Union or whatever state joined the Union. They go back and they just simply repeal it. That's all they have to do. According to the maxim of law, and I've heard Judge Andrew Napolitano say something about this, the way you get into something is the way you get out of it. You legislated yourself in, just legislate yourself out. The problem is that there's this, all this stuff about how everything is supposed to go. You know, it's for the first 150 years, people didn't really even know. Even the people in Congress didn't really even know how everything was supposed to be ran. Statutory enactments of various states have also fixed conditions concerning procedural aspects of federal acceptance of legislative jurisdiction. For example, some states require publication of intent to accept and recordation with county clerks of metes and bounds of the property, or to have other similar requirements. So again, we're talking about the federal government has certain lands to which they do federal things, and that's it. They don't do federal things off federal lands. It doesn't make any sense to even try to think about it in that way. It's not so. In the case of one state, these procedural requirements have been deemed by some federal agencies to be so onerous, and the reservations of jurisdiction made by the state to be so broad that the agencies have not felt justified in meeting the procedural requirements in view of the small amount of jurisdiction which is thereby acquired. Retrocessions by the federal government. By the federal government. Retrocessions by the federal government. That's giving back. The federal government giving back. Okay, now I don't specifically agree with this section, what it's saying, because I believe, if I remember correctly, what it's saying is that the states have to ask the federal government to give back the lands, and the federal government has to agree. I don't agree with that. If that were the case, then we're just locked in forever, because they're never going to give up. They're never going to let the states leave the Union. That's a form of slavery, isn't it? If somebody's doing something wrong to you, and then you have to ask them, well, can I leave now? I mean, they're going to say no. They're going to say no because they like doing bad things. So if the federal government is siphoning land and property and all these things off of the states and the states' people that is outside of their power, and then the state says, fine, we're leaving, and the federal government says, well, you can't, and we're just going to keep doing this stuff. I mean, that's an even bigger wrong than them having us for slaves, right? Not letting us leave. So yeah, that's ridiculous. So I don't agree with this area. The states could not by unilateral action retrieve from the federal government authority which they had surrendered over the areas as to which they had already ceded exclusive legislative jurisdiction to the government. But during the mentioned period when states were altering their consent statutes, the federal government relinquished to the states the authority to tax sales of motor vehicle fuels, to impose sales and use tax, and to levy income tax. These relinquishments or retrocessions were applicable to areas as to which jurisdiction previously had been acquired, as well as to future acquisitions. The term retrocede is used generally here and throughout this report to include waivers of immunity as well as retrocessions of jurisdiction. The statutes involved are set out in Appendix B in the codified form in which they appear in Title IV of the United States Code. So that's all I'm going to read for now, but I do want to look at, real quick, I want to remind you of a part of the government codes where you can look and see what it's talking about as far as the codes. And this is the OLRC, Office of the Law Revision Council, United States Code. You can find this just by Googling OLRC. And it appears to me that 1, 3, 4, and 5 are the real basic constitutional laws passed by Congress. Only the ones with the asterisks here, the first 4, which is 1, 3, 4, and 5. And that these titles not with an asterisk appear to be in support of these other titles. And I also want you to notice that Title II has not been passed into positive law. And what I mean by passed into positive law, if you're new here, is that a title is nothing. A title is just a bunch of stuff put together. The title is not a law. And the title cannot be used as evidence in any court of the United States as a law if it's not been made positive. So once it has been made positive, it has a positive law citation, and then it can be used as a law in the United States. And it's interesting that Title II has never been passed into law. So Congress is not following the law. In my opinion, that's what it means. This is just a compilation of a bunch of stuff that Congress does that's not ever been passed into law. Okay? The stuff in here may be passed into law, but when they accumulate it into a title as like a code, it's not passed into law. It's not a law. It may consist of laws, but the title is not a law. So when we go to organization and employees, and basically a lot of the stuff that this jurisdiction report is talking about is mentioned in the first 2 titles, 1, 3, 4, and 5. So these are good things to check out, okay? These are really good things to check out and just look through and read and click on and just kind of get familiar with them. But also I want to make sure that you understand that many of the laws in this title that's been passed into law and made law were passed in like the 40s and 50s. So they're fairly recent. See, this was the 47. Okay, so state and so forth, taxation affecting federal areas, sales or use tax. Income tax was for the federal employees. Okay, and I showed you that from the 39 code in a previous video. The 1939 statute on taxation, income tax, was for the federal officers and employees. Okay, so when you see in here where it says state, it's not always talking about the federal state. I mean, it's not always talking about the states that created the federal government. Oftentimes, it's talking about a legal state created by the federal government, which is a dependent state, and dependent states have no sovereignty. These dependent states include corporations, which are instrumentalities. And I mentioned instrumentalities in this document here somewhere. It said instrumentalities, and I told you instrumentalities meant corporations. Here it is. It should be emphasized that federal instrumentalities, corporations, which are dependent states and have no sovereignty, they have no authority, they have no jurisdiction, they can't make you do anything. And what do we have over here? A bunch of things that are not laws. Title 26, not a law. Intoxicating liquors, forcing you to get a license, it's not a law. Labor. Labor is mentioned in Title 5 for officers and employees of the federal government. So this title for labor is actually in support of Title 5, the laws in Title 5. Okay. Public lands is in support of Title 5 and Title 4. Okay. Sorry, I'm out of breath. Okay, so it should be emphasized that federal instrumentalities and their property are not in any event subject to state or local taxation or to most types of state or local controls. Okay, because they wanted the states to give up all rights to the land and therefore allowing the federal government to make the laws for those lands. However, if it's not for forts, arsenals, and those things listed in Article 1, Section 8, Clause 17 of the Constitution, then the federal government, according to the Constitution, didn't have the right to ask for exclusive jurisdiction over those areas, meaning the states never had to give up the rights to tax those people in those places. Okay, but it says, however, the transfer to the United States of exclusive legislative jurisdiction over an area has the effect, speaking generally, of divesting the state and any governmental entities operating under its authority of any right to tax or control private persons or property upon the area. It was the divesting of such rights that reservations and consent and cession statutes were designed to combat. Okay? It was the divesting of such rights that reservations and consent and cession statutes were designed to combat. So the reservations that the states made were designed to combat using federal lands for non-federal purposes and forbidding the state to tax the people on those lands. So I remember seeing in one congressional record that the federal government, when they put these Federal Reserve banks in the states, they wanted to specifically deprive the state of taxing the banks because they felt that the states would tax the bank out of business and the banks would eventually close and end. And so they wanted to get exclusive legislative jurisdiction over those areas so they could put their banks on them and keep the states from taxing the banks. Why the states agreed to this, I don't know, other than the states are just as corrupt as the feds. Okay, so that's why the feds wanted exclusive legislative jurisdiction over the lands in which the banks operated. Okay, now again, the Federal Reserve Bank is an instrumentality. It's a private corporation. We've heard that over and over and over again, especially from Ron Paul. And if you look here, Banks and Banking, Title 12, there's no asterisk, which means the title has not been made positive. And the things in it that are positive or are laws are not intended to be used off federal lands, but are intended to be used in support of the general provisions, the president, the flag, and the government organization and employees for the federal purposes. Okay, so I'm going to end this here and make a mark on my book so that we can know where we left off. And please like, share, and subscribe so that we can get more people to understand this stuff and get more people to know what it means to be free and where they find their freedom. And the more they know, the more free we can be, because remember, knowledge is power. you'll find freedom where you find power, your power. Okay, so I've been kicked off most social medias, and I mentioned that on all my videos in the end, pretty much. So I depend on people to like, share, and subscribe, and help me out by getting the word out. So I appreciate your time in listening to this video. I hope you understood it. If you have any questions or comments, go ahead and post them in the comment section. I may or may not have some argument about it or some comment to it. Sometimes I just don't have anything to say because maybe I don't know what you're talking about. Maybe I don't, I have to research it, or maybe I just totally agree and I have nothing really to add to it. But I want everyone to be able to post whatever they like to post, whatever comments, you know. And, it's good to see other people knowing stuff about this. So I will see you guys in the next video, and have a great day.